So welcome everyone to the Planning and Management of Literary Estates, an online seminar brought to you by the Authors Guild and Copyright Clearance Center. Now before we begin, I would just like to do a brief introduction to today's speaker. Our speaker today is Herbert E. Nass, Esquire, and he is the managing partner at Herbert E. Nass and Associates, founded in 1990. He was an associate attorney at New York law firms of Paul, Weiss, Rifkind, Wharton and Garrison, and Tenzer Greenblatt. He is a graduate of Horace Mann High School, Swarthmore College, and NYU School of Law. Herb Nass is the author of 3 books: Wills of the Rich and Famous, first published by Warner Books, the updated hardcover edition of Wills of the Rich and Famous, published by Gramercy Books, a division of Random House, and the 101 Biggest Estate Planning Mistakes, published by John Wiley & Sons. Herb is a frequent lecturer on the topics of wills and estate planning, with a special interest in celebrity wills and estates. Herb Nass has frequently appeared on television shows and news reports, including The Oprah Winfrey Show, Larry King Live, Entertainment Tonight, The Insider, The Early Show, and Court TV, CNN, and Fox News. And with that, I'd like to pass the presentation over to Herb.
Thank you very much. We're here in the middle of New York City, and I'm in my office with 2 of my associates, Scarlett Taylor and Diana Grangio. And if I say anything wrong on this, they're going to signal me and maybe bail me out if they have to. But today I want to talk about the benefits and mechanics of a literary property trust in the context of estate planning. So I consider myself a trust and estates lawyer with some familiarity with copyright law, and I'm not the other way around, a copyright lawyer with familiarity with trusts and estates. But I know enough copyright law to be dangerous and to help our clients with their estate planning involving copyrights. So let's start by just talking about trusts in general. And, you know, what is a trust? Everyone hears that term, and really what a trust is it's an agreement. And the basis of a trust is a trust agreement that can be set up during your lifetime, which is what we're going to focus on today. Or a trust can also be under a person's will. So that's called the testamentary trust, as opposed to an inter vivos trust that you set up during your lifetime. So assuming it's an inter vivos trust, it's an agreement between a settlor or a grantor or a donor, and in our case, we're going to add the title author. So the person who decides to establish the trust is that settlor, donor, grantor. And then there's another party involved, and that's a trustee. And so the trustee is the other party to the agreement, and we'll get to this, but the settlor can also be the trustee in certain circumstances. And that trust agreement is established to own literary property. So that includes not just the copyrights, but also the physical material, your manuscripts, your first editions, your marked up, edited versions. So any physical object related to your literary property can be owned in the name of the literary trust. And that trust, of course, is for the benefit of a beneficiary or beneficiaries. And the terms of that trust can be very creative. I always tell clients, as long as it's not illegal, we can prepare it the way they want it, generally. So every trust is a little different, but we'll talk about literary property trusts in particular. So just getting back to the issue of who should be the trustees, the settlor author of the settlor who is an author can act as the sole trustee of his or her trust and name a successor trustee that would take over if the original trustee were disabled or resigned or died. So the successor trustee comes in right away and takes over the handling of the trust. And, you know, in that context, you want to name someone as a trustee who's not only familiar with your work, your literary work, but also with the the literary world in general and understands publishing agreements and royalty payments and copyrights to some degree, and just someone who's qualified to handle all of the issues that might arise in connection with your literary property. And the trustee can certainly hire a lawyer with expertise, an accountant, an advisor, so he or she doesn't have to feel that they do it alone, but they are in charge and they're responsible. So the choice of trustee is very important, and successor trustee, of course, as well. In terms of the terms of that trust, the settlor author would determine what he or she wants, and those directions, instructions would be built into the drafting of the trust. So first issue is what property is going to be owned by this trust. So that's the author's decision. Which copyrights, often it's all of their copyrights, are going to be transferred into this trust. They're also going to determine which physical objects, papers, books, manuscripts, etc., would be transferred into the name of the trust and then pass pursuant to the directions of the settlor. And so, for example, a famous author could state in the trust that upon his or her death, all of his or her manuscripts and first editions and correspondence could go to a particular institution, a library, some institution that it's best if the authors discuss this first so that the institution's not surprised, but the author can certainly earmark certain property for certain institutions. And then the bigger issue, of course, is regarding the copyrights and how those are going to be handled in the future. So whether there's going to be any restrictions on the copyrights. For example, whether the work, you can also provide whether your manuscripts or unpublished works can be published posthumously. That's something you can put in your trust agreement, make it clear that what the successor trustee's rights are. So the terms of it can be very broad. You can include all of the beneficiaries you want, charities, individuals, and of course, and spouse among the individuals and children. And those choices will have an impact on tax issues, which may or may not be that relevant in the years ahead. By that I mean that the federal estate tax is being, it looks like it's going to be eliminated, although no guarantees with this administration. But the state estate taxes are also getting more favorable. So in New York, for example, if your estate currently is less than $5,250,000, there won't be any state estate tax. And the federal exemption amount is currently $5,490,000. But as I said, that may be going away in the near future. So depending on how the property passes after your demise, that will determine the tax issues, but those may be moot in some way and not that crucial going forward. But let's talk about what the advantages of setting this type of trust are and why it's beneficial for authors to do it. And obviously I've set up several for various authors over the years, and I think for the most part everyone's been pretty happy that we did it. It just, in retrospect, it's worked well and has achieved the goals we wanted to achieve. So the first advantage of a trust, and this is not just a literary trust, but any trust, is by having property owned by a trust, you avoid that term that you all hear called probate. And probate, what it really means is to prove a will. So sometimes the word probate is used to talk about the estate administration in general, but really it means proving a will, going to court, getting the court to agree that this is a valid will. And that process can go very smoothly and quickly. Could be as little as a week or two, or it can drag on if there's a will contest or some problems with the will itself or the witnesses to the will. That can really drag on and hold up an estate administration. But if instead you have transferred your literary property to a trust during your lifetime, upon your death, that trust continues. There's continuity. The successor trustee immediately takes over when you resign or stop acting as a trustee. So he or she can continue to manage your literary property regardless of what's going on in the probate court. So that's certainly an advantage. You know, one of my hobbies is collecting wills of famous people, and for many years I was trying to find the will of J.D. Salinger, who I believe lived up in New Hampshire, if I recall. And I called the court and couldn't get it, and ultimately I guess I heard from someone, oh, Salinger set up a trust years ago, and all of his property, not just his literary property, is in that trust. And of course, that trust is not necessarily a matter of public record, so it doesn't have to go to court. No one has to have access to it as I would if it were a will. So for the reclusive J.D. Salinger, who was well known as somebody who liked his privacy, really privacy very important to him, a literary trust helped him to maintain it even after he died. So that's one thing. So it's the notion of continuity and privacy, confidentiality, all those are achieved with a trust. And continuity is important when it comes to literary property, because sometimes after an artist, whether he's a musician or she's a musician or a writer, sometimes right after their death there'll be some increased activity in their interest in their work. And that can lead to offers that it's helpful for someone to be in a position to field. So if there's a book, an author who died who wrote a book that somebody reads about in their obit and realizes this would make a great TV movie, it would be good to have someone in place who could start that discussion right away. Because in our society, people have very short memories, and as soon as the next author dies, that TV producer might be on to the next one. So having someone in place who has authority to transact business is very helpful. And as I said earlier, that can be delayed if it's going through the courts and there's a will contest, and that can scare potential purchasers or partners away. So, you know, the moment the trustee dies, the new trustee takes over at that moment. You know, the king is dead, long live the king. It's that kind of continuity that you achieve with a literary property trust. And of course, the terms of the trust don't change. They stay the same. They could. The trust agreement could be drafted so they change after the death of the grantor. But for the most part, the structure's in place, and the successor trustee takes over that structure and continues to handle the literary property in the same manner. What's also beneficial about a literary trust is you can centralize the management of your copyrights and your physical objects, literary property objects. So rather than having potentially different people involved with different copyrights and different issues, it's all centralized with the trustee, who can look at the literary estate as a whole and can kind of make decisions based on the whole body of work rather than just one title or another. And that might also help to avoid, you know, infighting in a family or among advisors of the decedent, the author who passed away, because the decision has been made in advance that all of these properties should be controlled by the one single trustee. And of course, it can be 2 trustees or 3 trustees, and sometimes it's good to have a group of 3 if there's significant issues. In most cases, I think a single trustee is a better choice, but 2 trustees can be problematic, because if they disagree, you have a problem, because it's 1 vote per trustee. So an odd number of trustees is ideal. Not odd trustees, just an odd number. So 1 or 3, I think, is my preference. But digging in a little deeper on literary trusts, the copyright issues obviously are very important, and once the copyrights on those properties are owned in the name of the trust, then the trustee has the right to step into the deceased author's shoes and make all of the decisions that the deceased author would have needed to make. So that applies to original works that have been published and also unpublished works. And the trust agreement would usually provide that the trustee has the exclusive right to reproduce the works, to prepare derivative works, to distribute the works in some fashion, to perform them in a public forum, to display them in a public forum. So all of those kinds of copyright, part of the bundle of rights of copyright, the trustee has the same rights as the author does. And as you all know, a copyright generally endures for the life of the author plus 70 years. So after his or her death, the literary trust can manage those same copyrights for another 70 years, and in view of that, you probably want to think about a successor trustee, because you don't want your successor to trustee, he or she may not be around after 70 years, so it's not a bad idea to either name a third one or to have a mechanism in the document for naming a third one. And you know, we're talking about death primarily, but of course this would all apply if the author were incapacitated during his or her lifetime, so that the trust would say if the author couldn't manage the property or couldn't act as trustee, at that point the successor trustee could step in. And that successor trustee can, again, because it's owned by the trust, he or she can renew or extend copyrights as needed, can register literary works that were previously unregistered with the Copyright Office, can publish literary works that were previously unpublished, obviously subject to the author's desires. So that's important. If you don't want them published, you got to make it clear to your successor trustee that that's very important that they not be published. The trustee can sell, transfer, or license all or part of the copyright, and can break up the bundle of copyright interests and transfer some or all of those. The trustee can enforce copyright protection through litigation, so that if someone's infringing the copyright, the trustee can come in and start a lawsuit. The trustee really has a moral obligation and a fiduciary one to maintain the legacy of the author, his or her, make sure his or her name stays out there and that people are still buying the books of that author. Of course, most important, the trustee can collect royalty payments due to the author for the copyrights. So those, once the copyrights are registered and recorded in the name of the trust, the royalty payments can be paid directly to the trust. If it's set up, really high-tech, those payments can be going direct deposit into a trust account, so that regardless of who the trustee is, they just keep getting paid as they come in. And then once those payments are received by the trustee, of course, has a fiduciary obligation to make sure that those funds are being used to benefit the people or organizations that the author desired. So let's talk a little bit about transferring copyrights into the trust, how that's done. It's best if the copyright has already been registered with the U.S. Copyright Office, but it is not required. Without getting into a discussion of copyright laws, you know, the copyright kind of inures upon creation of the work, but recording it and registering it, rather, with the Copyright Office gives you additional statutory rights that you wouldn't have if you don't register it. So it's a good idea to register copyrights in general, relatively quickly, and most publishers will do that for the authors as part of their services. And one thing we would do if we had an estate or a new client who's an author is we'd probably try to get a copyright search at the U.S. Copyright Office and just basically ask them to give us a list of all the registered copyrights in the name of that author. And they charge for that, and I don't recall the amounts. It's not a crazy amount, but it's helpful because it gives you really the specifics of when the copyright was registered and in whose name and other details like that. So the way to assign the copyright to the trust is with a document that we would call an assignment. No surprise there. And basically it's a list. It would be a list of all of the copyrights owned by the author that you want to assign to the trust. And or when I say copyrights, I also mean physical property. So, you know, the assignment is dated and it's signed by the author, who's the assignor, and assigning it to the William Shakespeare Literary Trust, dated 1566 or something. But all his works are in the public domain, so that's a bad example. But the assignment basically is a legal document that is signed and can and should be notarized, that has a schedule attached of all of the copyrights, all of the titles that are being assigned to the trust. So in terms of that assignment, you know, you want that to be pretty broad generally. You want it to be all of the author's rights to the copyrights and the physical artifacts. And I'm looking at one right now, but it's just a broad, very broad language that it's really transferring everything that the author owned to the author's trust. So that assignment gets signed, and at that point, the author has effectively transferred his or her ownership to the trust. At that point, it's a good idea to record that assignment with the U.S. Copyright Office. And last time I did it, it was about $100 to record the assignment. But that way, there's a permanent record that these copyrights have been transferred and assigned by the author to such and such trust. Now, when you record that assignment, the Copyright Office doesn't really make a determination whether it's legally proper or sufficient. They just record it and return you documents showing it's been recorded. So it's important when you do that assignment that it be done properly, that it have the one that's sent to the Copyright Office have an original signature on it. I think there's a procedure for a certification of a photocopy. The assignment should be complete by its terms, very comprehensive and very clear as to what's being assigned. Obviously, it needs to be legible, and then it needs to be accompanied by the correct filing fee. So that's the kind of basic mechanics of a literary property trust, and I don't know if we want to break for questions now, because I do want to talk a little bit about a charitable remainder uni trust. So if maybe now's a good moment to break for some questions. I know there were some questions prepared prior to this call. And let me just try to talk about a few of those, if I may. One moment, it's around here somewhere. Okay. Yes, I think that's. Okay, I got it. So Casey Bassett had sent me a list of some questions, which I'm still looking for. But let me keep going, and we can maybe pick up some of these questions at the back end. Let me talk about another type of trust that I actually had done for a a member of the Authors Guild years ago who was referred to me by the Authors Guild, and she wanted to establish what we call a charitable remainder uni trust. And that has an acronym, like many things in my world do. It's called a CRUT, C-R-U-T, Charitable Remainder Uni Trust. So what is a CRUT? It's an irrevocable trust which pays a fixed percentage, which needs to be at least 5%, of the market value of the principal valued each year. And that payment is made to the donor for the life of the donor or for a specified period of years, after which the remaining principal passes to charity. So I did this for an author of the Authors Guild who's passed away, but she funded her CRUT with $250,000 for the balance of her life. It provided that she would get 8% a year based on the fair market value. So on $250,000, I guess that's about $20,000 a year. And then upon her demise, what was left in that CRUT actually went to the Authors Guild Foundation. So it was a win-win for everybody in that the donor, when she funded this CRUT, since it was irrevocable, and she was basically putting that money in a place that she could not reclaim it, she was entitled to an income tax deduction for the present value of the amount that would ultimately pass to charity. So an example of that, not the case I mentioned, but another kind of generic example, a 65-year-old person who might put $250,000 to fund a CRUT for a life term, which pays 5% to the donor each year, he or she, for a 65-year-old, would get a charitable deduction of $25,000 approximately. And that's because the remainder interest, based on the life expectancy of that person that is passing to charity, is worth $25,000. So when the year was funded, the author could deduct $25,000 against his or her income, subject to certain limitations. But if the person were older when they set this up, the deduction would be even higher because their life expectancy, of course, is shorter. And from the Authors Guild point of view, it's found money. It's not, there's no, they are not responsible for paying the 8% or the 5%. The CRUT itself does that, but upon the death of the author, it then goes to the charity. And what's good is, well, there's some other tax benefits related to that. So since this trust is a tax-free entity, a tax-exempt entity, if the assets that were contributed to the trust had a low tax basis, in other words, if the stock that's transferred to the trust was worth $10 when the author bought it and it's now worth $100, the sale by the trust of that stock is not going to result in a taxable gain because it's a tax-exempt entity. So whereas if the author had sold it, there is a gain. Here, the author is able to move that highly appreciated asset into a trust that's sold, that generates more net proceeds for the author because there's no tax to pay. So rather than paying capital gains tax, the trust sells it, makes its gain, and all those funds are then available to generate the income that the author needs and wants from this trust. And the income stream retained by the donor generally will be larger than that the donor could have received from investing the after-tax proceeds from the sale of the property, because in this case there's no tax on the capital gain. CRUTs are also beneficial because they protect the beneficiary against inflation, because if the trust principal is invested in a growth assets, the distribution to the author will be increased also, because it's a percentage of what the trust is worth at the end of each year. So if the $250,000 trust grew to $300,000 because it was invested well, then the author gets 8% of $300,000 instead of 8% of $250,000. So it's kind of a hedge in some way against inflation, because as the trust grows, you can, you know, the income to the author grows as well. So those are some trusts that I think would apply to authors. Obviously, estate planning in general is important for everybody, but I think a literary property trust is a very helpful vehicle. So let me ask a couple questions that have been submitted last year and recently, and I'll ask the questions and answer them, and then we'll throw it open to other questions. Ladies, anything you want to jump in on? Okay. So one question that came up last time was, is it better to have a literary property trust that owns exclusively literary property rather than a trust that owns various types of property, including literary property? It certainly could be done either way, but my feeling is it's better to have a literary property trust that owns almost exclusively literary property. I mean, obviously, as income comes in, then there's a bank account and there's cash in the bank, but the corpus of the trust should be the literary property, and that's just to have the focus be on the literary property, because presumably you've appointed a trustee who has special understanding or expertise related to literary property, so that same trustee may not have the same expertise related to other types of property. And then, as we said, the literary property has copyright issues that other property does not have. So that was one question that came up.
Hi, Herb. Casey here. I did get a number of questions submitted via email and chat here. If you'd like me to go over some of them with you, if that's okay.
Yes, please, Casey. Thank you.
All righty. All right, so we had one question here asking, what if a literary executor is named in your will without an existing agreement?
Well, a will is a unilateral document, so it's your will. You can't force somebody to be a fiduciary, a trustee, or an executor. So the answer is it's good to have a discussion with that person before, but you don't need a formal agreement if it's a trust under a will, because that only becomes effective upon your demise. But you don't want to surprise your trustee by foisting this upon him or her without some advance notice.
Thanks, Herb. So we have another one here from an attendee asking, is it advisable to create a trust for a collection of copyrights and papers valued at under $10,000?
You know, the value is ultimately a subjective notion in some ways. But, you know, I guess the question is, will it justify the costs of setting this up if the property is of that value? And I'm not sure at that level it would. I mean, I think, you know, all creative people are sure their next painting or their next book is going to be a bestseller, but sadly doesn't always work out that way. And I think an author needs to be realistic about the likelihood of things changing after his or her death, you know, dramatically. So I guess the short answer there is, if the property's worth less than $10,000, I don't know if it's worth the time and effort to set up a literary trust.
Thanks, Herb. So we have a two-part question here from one of the attendees. Part one is, how soon must the author transfer copyright before going into a nursing home? And I'll wait and ask part two after you address that part. How's that sound?
Well, that's fine. You know, that gets into elder care law, which really is about Medicaid planning and divesting your assets to qualify for Medicaid, and it's not my area of expertise, but I'd say if that's a concern, the sooner the better. And I believe there's a look-back period of 5 years so that if that property has substantial value and or generates substantial income, it might come back into the analysis of whether you qualify for Medicaid if it's done within 5 years. So I'm not answering that question fully because I'm not an expert on Medicaid planning or elder law, but I guess the short answer is the sooner the better. And, you know, it could also be transferred to your children. Doesn't need to be transferred to a trust. Could just be put in made your spouse and children's assets.
Perfect.
So
thank you. So we have another question.
Part of that?
The second part was if the author did not transfer copyright before going into a nursing home and the 5+ years have passed, is any income still subjected to Medicare recovery?
I'm going to say I don't know offhand. My guess is it is. It would be subject to Medicare or Medicaid claims.
All right.
And states also, it's not just the federal government, but like New Jersey is very, very careful about recovering funds that it has expended on behalf of, for medical services for its citizens. Right.
Thank you very much. So there's a question here that we got via email, actually. Someone asked, I've been told that if I put my copyrights inside a trust and I fail to name one possible source of royalties, the trust can become invalid. Is that true?
I don't think so. I mean, first of all, in the trust agreement, you wouldn't normally name the source of the royalty. The royalty follows the copyright. And once the copyright's owned by the trust, those royalties should flow to the trust. But that would not, I don't see how that would invalidate the trust if there's a source of income that hasn't been factored in or isn't, or if the author's not aware of that, but it's still, as I said, the income follows the copyright. So if it's owned by a trust, then all the income related to that copyright should go into the trust.
Perfect. Thank you. And again, I just want to remind everyone, if you do have any questions, you can send them directly to us in the chat box or via email. And we're talking with Herb Nass here. And the next question, Herb, we have is, what about a group of some 40 books written with a co-author? Both of us are still alive and hope to be for a long time. But now I'd like to do an estate plan and want to know how to address these works written mostly in the 1970s and many of which are OP.
OP meaning public domain? What OP?
Probably out of print.
Out of print, got it.
Thanks, Michael.
Well, whether they're out of print, you know, the copyright still inures whether they're in print or not. You know, that's a joint work. So each author has, and I'm not sure I have this 100% right, but each author owns the copyright in the work. So it would be for his or her life plus 70 years. So I think you could have a trust where they both have transferred their copyright, and probably you could even have a trust where each transfers his or her copyright. But a joint work, it's a little more complicated because the author doesn't have total control over that, and it's obviously subject to the co-author's wishes as well.
Perfect, thank you. We had a question here. Someone wanted to know, where do you go to establish value of the literary estate?
So that's an excellent question because that comes up often on the estate tax returns that we prepare. And actually, Scarlett and I worked on a evaluation of copyright royalty for an author's family, and I believe maybe it was the webinar we did a couple years ago that she was listening to, but I'm not sure of the source. But the answer is it's ultimately a formula that is based on average copyright royalty. What we often do is look for the prior 5 years get an average of what the total royalty was for that author, and then come up with a multiplier somewhere between 3 and 7. And don't ask me where I got those figures, but that's kind of the range of standard multipliers. So in that case, I guess the author's royalties was about $50,000 average over the prior 5 years, and we took a multiplier of 4. So on the estate tax return, we valued, and my office did an appraisal, and we did a statement of the valuation, and we came up with about a little under $200,000. And we submitted our valuation to the accountant who was preparing the estate tax return, and I've actually not heard whether they got a closing letter on that or if that was ever disputed. I suspect if it were disputed, I would have heard. So I haven't heard, so I'm hoping that what we wrote made sense to the IRS in New York State, and they agreed with our valuation. But ultimately, just like any asset that is on an estate tax return, the IRS or New York State can question your methodology or your appraisal for the value of that asset. But it's you know, I first did this when I was a first-year associate at Paul Weiss in 1984 or 85. I was involved with the estate of Theodore White, who wrote The Making of the President, and you know, all the things I'm saying today I learned to do back then, and copyright search and all that. And you know, the fact is, most authors' royalties are not that substantial, unless your name's Grisham or Thoreau or many other successful authors. But most of us, myself included, our royalties are pretty de minimis. And even somebody as famous as Theodore White, who you know, made most of his money when the book first came out and the publisher's advance and all that. But at the end of the day, once a book, The Making of the President 1960, has been published and read in the first year or two, it really doesn't have much of a shelf life, and the royalty income will be down dramatically after that. Now, there's certain perennial books that, you know, To Kill a Mockingbird, I mean, that one sells phenomenally, and so Harper Lee undoubtedly got a lot of royalties, and I wish she were my client, but she's not. So she got a lot of royalties over the years, and you know, and her death probably even heightened the royalties. Sometime there was a case of Andrews versus Commissioner was the big, just looking at my notes here, the famous case on how to value, State of Andrews versus U.S. It was done in 1994. The citation is 850 F Sup 1279. And that case had a lot of good review of how to determine fair market value of copyrights. And, you know, some of it has to do with whether there's going to be additional books in that series, whether there's going to be a movie made based on the characters in the books. And if none of that's happening, then probably the copyright royalty is going to be pretty minimal. But that's an important question, and it comes up, and I would just direct everyone to Estate of Andrews versus U.S.
Thank you very much. So another person asked here, if an author specified in their will that a trust which owns the copyright must terminate in less than 10 years after their death, can the designated trustee continue the trust? If not, how handle the royalties which will continue to accrue?
Well, I mean, that would be short-sighted for the author to require that it be terminated 10 years later, considering the copyright income could continue for 70 years. Can the trustee not do it? Well, if the trust says terminate in 10 years, the trustee really has to do that. I guess there's some possibility of what we call decanting, moving the property in that trust into another trust, and that's a possibility to extend the term of the new trust beyond the 10 years. But generally, the trustee is bound by the terms of the trust, but there are ways around it. I mean, anybody who sets up a trust would not be happy to think that their instructions are not being followed, but there are ways around it. So, so I'd say a 10-year term is not a good idea, because then it would be distributed to your heirs, your children, your spouse, and that's when all the problems that you avoid by having a trust would come up, by having it owned by disparate people, by a group of people rather than a single trust. Okay?
Perfect.
So that's my view on that.
Thank you. And we have great questions coming in. I think they're still coming in right now, so let's keep going. In fact, we've had a lot of questions that are similar to this one, and it's, can someone name an organization as a trustee for an author, for instance, without any family members?
Well, certain organizations, yes, but not every organization. The organization, and it's usually going to be a bank, has to have trust powers, which basically are granted by states to allow them to act as trustee. So I don't know if the Authors Guild has trust powers offhand. I don't think so. Maybe Michael has an answer on that.
I'm not sure either.
Usually it's the corporate entity would be a bank that could act as a fiduciary, as a trustee.
Perfect.
Michael Gross, you're on the line, yes?
Yes, I'm here.
No. Does the Authors Guild ever act as trustee of trusts?
I'm not sure.
Yeah, I don't think so. I mean, I don't think so. It's a not-for-profit, of course, but I don't believe it has trust powers. But with that said, an individual at the Authors Guild could be a trustee. So,
right.
Guild has a lot of smart people there, and if an author has a relationship with one of those people, that person could be the trustee. Because, strangely enough, an individual does not need trust powers, just a bank. But an individual needs to be a U.S. citizen for the most part, can't be convicted of a felony. I mean, there's a few things that do apply to individuals, but most entities cannot be trustee, only if they have been granted trust powers by the state government. That's in New York State. It might be different in other states.
Thanks for that.
And, frankly, unless there's complicated assets involved, I think an individual is a better choice because they're going to pay more personal attention to your situation than a bank or corporate fiduciary would. So, and by the way, trustees, just so we're clear, get compensated for being trustees. They're entitled to a commission. It's set by statute. So it's not a totally thankless job. You can also say your trustee shouldn't be paid, but I don't recommend that because it is a job and there is responsibility and potential liability, and it only seems fair to me that they do get compensated for the work they do. And it's a small percentage. It's a 0.5% a year in New York, approximately, depending on the size of the trust. Could be as much as 1% a year, but usually less. All right, next question.
Next question here. This one was emailed to us. This person said they've been told that spouses do not necessarily inherit intellectual property, even if they have been made the only beneficiary in the will. She wants to know if this is true. And then she also followed up saying she's an author and has an intellectual property trust, but her husband, a visual artist, does not.
Well, let me start with the back of that. The visual artists, and I do a lot of work for visual artists. As much as I like authors, I like painters and sculptors even more. Usually visual artists aren't getting royalty income. They make art that they sell, and the copyright in the painting is really a very minimal value, whereas a copyright in a book that sells 1 million copies, that can be quite valuable. So it's not uncommon for visual artists not to have you know, obviously it's not literary property, but not even to have a trust like this. Although we do it, you know, we do it for different reasons, but the income that a visual artist gets from his or her creations is very different from the income or the timing of the income than an author. As far as how the copyright goes, this is more of a copyright issue, and I'm sure Michael Gross has a better answer than I do, but I believe children and spouse share the copyrights. I'd have to check that. I didn't check the copyright statute, but children have rights as well that they share with the spouse, with the surviving spouse. Am I right about that, Michael?
That's my understanding as well, yeah.
Okay. But copyrights, you know, it's a whole nother webinar, a whole nother seminar. But again, that's why literary property trust makes sense, to avoid that kind of division of the property and any potential division in the family as well. All right, next question.
All right, next question. Are there any differences with a trust for a self-published book, since the author is making all of the money from sales and not royalties?
It's really no different. I mean, you know, the sales are, you know, I mean, they're kind of like royalties, but just bigger, because they're not going through a publishing house and an agent. So same concept. It's income related to the literary property. So I think it's comparable. You know, no basis not to do a literary trust for a self-published book. You'd want to transfer that copyright for your book into your trust, and that way any sales income goes directly to the trust. So I think I answered that one.
Perfect.
Yep.
Thank you. So the next question here, someone wants to know, what are the merits of donating the manuscripts, drafts, correspondence, and physical artifacts of an estate versus selling them? If selling them, how is the value typically established?
Well, on a sale, you know, the way the IRS determines fair market value is what would a willing buyer pay to a willing seller, neither of whom is under any compulsion to buy or sell. So how do you establish value? You know, you offer it to a potential purchaser, and if they agree to your price, that's the value. What was the first part of that question, Casey?
What are the merits of donating the manuscripts, drafts, correspondence, and physical artifacts of an estate versus selling them?
Well, I mean, donating, you get a charitable deduction if it's going to a charitable entity.
Actually, really, when you donate those things, you're only going to get the value of the paper and ink. There's a tax law that specifically prohibits the author from donating and getting the full value deduction.
Right, and that's true for artists as well. That's why they don't tribute their paintings.
Right.
So, I mean, I think the answer would be, if you can sell it, then take those proceeds and then donate the proceeds to charity or part of the proceeds. Right. Then there's no question about the amount of the deduction.
Yeah.
And, you know, donating, I mean, there are psychic benefits to donating to a charitable institution versus selling to somebody. I mean, I guess when you donate to a charity, you can prescribe some of the terms and what you expect them to do with your work, whereas if you sell it, it's harder to put those kinds of restrictions on it. For example, you know, if you give your manuscripts to, you know, University of Texas, which I think James Michener may have done, somewhere in Texas. So he can determine who has access, I mean, by agreement with the recipient, who can have access, what they can see of his work, versus if you sell it, you know, it's hard to sell it and put restrictions on it. So I think you have a little more control if you donate it, but at the end of the day, you're not going to get much of a deduction, as Michael correctly pointed out.
Thank you very much.
Now, your estate is different, because in your estate, the property gets what we call a stepped-up basis. It becomes, there's a new basis, which is the date of death value of the property and what is it worth on the date of death. So if your estate gives your $100,000 collection of manuscripts and correspondence to a school or charitable institution, that $100,000 of value in your estate is offset by a $100,000 deduction. So there's no tax, it's really tax neutral. But you do get a larger deduction, but doesn't really help you directly.
Thank you very
so
much.
I think I got that one.
Yep. There's a question here. When all of the executors of an estate have passed without naming a new executor, how does a new executor get appointed?
Well, estates don't go on forever, and some people think they do, but the executor's role usually is a 1, 2, or 3 year engagement, depending on the estate. I've had a few that have gone longer than that, but many of them, especially if there's no tax return that needs to be filed, no reason the will can't be probated and the estate opened and closed in a year. But the answer is, the question was, how do you name an executor if the estate's still open and there are none left? Well, you got to look at what the will itself says for how to do that, and often there's a mechanism in there for doing that. Otherwise, you got to petition the surrogates court or probate court for somebody to be appointed a successor executor. So that's why it's a good idea to name a series of executors in a will, and younger people than yourself, people who will be around after you are to make sure your assets are collected, your debts are paid, your bills are paid, and then that the terms of the will are executed. And all that can be completed in a year or two or less. I mean, need not take a long time if it's not a complicated estate.
And as a follow-up to the last question, someone wants to know, what if a trustee dies? How is the next trustee appointed?
Well, again, the instrument, the trust agreement should provide for that contingency, because we all know we're all going to die someday. So if the trust itself has not named a backup, usually we say that the acting trustee has the right to name a successor if the instrument doesn't. So the named successor trustee might be able to sign an appointment of a successor to himself or herself that would be binding. Or if that's not done, then sometimes you got to go to court, which is a last resort, because that gets expensive and time consuming. So best to have a series of trustees and/or a mechanism for appointing successor trustees.
Great, thank you. And then someone just wanted clarification and wanted to know if you could repeat the citation for Estate of Andrews.
Sure. So it's a federal. Pulling it out. Estate of Andrews versus United States from 1994, and it's in the federal supplement. So it's the 850 volume, 850 F sup, and it's on page 1279. And it's a case from 1994. And really still the governing law on this issue of how to value copyright royalties.
Thank you very much. And there's one, something just popped in here. Someone wants to know, maybe Herb and Michael, you guys could both answer this one. If an Authors Guild staff person was named a trustee and they leave the Authors Guild, I assumed the trustee duties stays with them after they leave. Is that correct?
With the individual, yeah, because you're naming an individual, not an organization. So, but you could also make the appointment of that person conditioned on his or her being an employee of the Authors Guild, so that if he or she leaves, automatically the document would take that into account, and then you'd go to the next person. Or you could do it the other way and just say, Michael Gross is a smart guy, and wherever he is, I want him as my trustee. So anyway, I think, you know, it's really, depending on how you draft it, it would stay with the individual unless you say otherwise in the document.
Perfect. Thank you. And there's a question, is it possible to have the copyright switch on your death to being a Creative Commons non-commercial license?
To being a what? A creative, what is that term?
A Creative Commons or a non-commercial license.
I'm not sure I know the answer to that. I would think you could put that in a will.
Yeah.
If the if the author wanted to donate his work and make it publicly accessible, I would think that a will could accomplish that.
I would think so. I mean, if it's the author's property, he or she can do, you know, can direct that it be held in. I don't know. It's a complicated question. I'm not sure you can really easily divest yourself of your copyright ownership. But I'll defer to Michael on that. I don't know the answer.
Maybe they'd create a trust to have it run as a Creative Commons, perhaps. I don't know. Maybe they could do that.
Yeah. I mean, I'm not that familiar with this concept of Creative Commons.
Yeah, so it's relatively new. Yeah.
All right. Well, better not to be too cutting edge with these things. They don't always work out.
Someone wants to know if you could talk a little bit about how royalties and rights to publish books should be addressed in wills for heirs.
Well, you know, the royalties are an asset of the estate, and in the powers clause of the will at the back where it has all the powers of the executor and the trustees, it should be very broad to include the right to, you know, negotiate contracts, to terminate contracts, to accept royalties. So that's just kind of a standard power for a fiduciary. Even if the will were silent on it, I'm not sure it would matter, because it's not like the income is, you're not going to waive your right to that income as an estate. And, you know, hopefully the will is, the person signing the will makes some reference to the literary property, but if they don't, I don't think it's a problem. It's still an asset like any other asset. You know, it's different from other assets, but it's still an asset that an executor would be able to take control of. So, but again, I would put some additional language in the will or trust to make sure that all the things that someone needs to do with literary property are allowed or expressly allowed by the document. And, you know, the termination of rights is kind of we're hearing more and more about, and a lot of authors don't realize that, you know, 35 years after they first grant the copyright, there's a period when they can reclaim it and abrogate agreements that were, you know, done previously. A lot of musicians who sold their copyrights for nothing are realizing that if they can get out of those agreements, they can reclaim some valuable copyrights, and there's been a lot of litigation in the music world on that. So you just want to just make sure your executor or trustee has the right to do those things, terminate contracts. And, you know, when we have a new estate of an author, that's the first thing one of the first things we focus on is what's the time frame. There's kind of a window of time. It's like a year before the 35th anniversary and not sure how much after, but there's a relatively short window during which this has to be done. So that's something we would focus on in an author's estate.
Okay.
I think I answered that one okay?
Yes, you did. And we have a question here. Someone was just looking for a clarification. I think they didn't understand something that you said it was actually the beginning of the webinar. It was a word that sounded like settler and had to do with an author settler, and wanted to know what, just clarification on what that word was, if they had it right or wrong.
Yeah, well, the settlor or the donor, D-O-N-O-R, or the grantor, those are all the same concept. That's the person who establishes the trust, settlor, grantor, donor. You see all those names?
Yep.
And I just was saying, in this case, it's usually an author who's acting in one of those capacities. So, you know, you see all those words are kind of interchangeable.
Perfect. Thank you so much. All right, so we had a lot of questions. Right now, I don't see any further questions coming in. So I think that's it. Herb, do you have anything more you'd like to say?
I think we covered the bases. We're happy to speak to any of the listeners directly if they want to reach us. I think our contact information is on the screen, I think.
Yep.
So we're happy to help authors and artists and anyone else with their estate planning.
Perfect. So I'd like to thank Herb so much. Thank you for joining us and talking and answering all those questions. I think it was really great. Sorry, I was just looking through and seeing if there's any further questions that came in. But I really appreciate it, and Michael, I appreciate you sticking around. So thank you, Herb, for joining us today and providing us with this webinar.
Mm-hmm.
And thank you, Michael, for sticking around. Michael from the Authors Guild and sticking around and
no problem.
answer questions. And if anyone has any further questions, you can email us at education@copyright.com. Or if you have any further information about joining the Authors Guild, you can contact them at staff@authorsguild.org. And I hope we got to all the questions. If we didn't, just shoot us an email or give us a call and we can follow up. And with that, I'd like to give everyone back, 15 or so minutes of their day, and have a good rest of your day. Thank you.
Thank you.
Thank you.
Thank you, everyone. Take care.
Bye now. Bye-bye.
Bye.